Hi, greetings. My name is Abhivardhan. I'm the founder of iSail and the curator of the Bharat Pacific. It's a pleasure. This is the first episode of Indus Think Season 4 as we know it. It's been, I think, nearly more than a year since Indus Think was, kind of done away with. But as we did our spaces on Glocalize with our friend Aditya Jakki, we just had a discussion with Arun on Indian semiconductors missions. I thought, let's restart Indus Think. And as Indus Think has always been, we will discuss about three dimensions: culture, technology, and policy. So, with this inaugural episode of Indus Think after some time, season 4, uh, you know me already. I am a technology law entrepreneur, I'm a technology law consultant. I have been leading what we call the Indian Society of Artificial Intelligence and Law. I'm also the founder of Vlecta.app under process and AIAct.in. Vlecta.app is a library of our work so far, and AIAct.in is the draft bill which we are going to discuss today. So before we move on with the monologue, which we have, and live comments can be accepted on LinkedIn, YouTube, and X. So feel free to send your comments to me as I unravel the Draft Artificial Intelligence Act for India, which is, in my humblest knowledge, the first and only AI Act proposal from a private organization, from an Indian so far. It is not a Government of India proposal, to be very fair. It is a proposal from my end, my organization's end. So let's be clear about that. And this is a proposal from Indic Pacific with the support of iSail. First, I think if you know me, you know iSail, you know the Bharat Pacific, you have been seeing the update that the Council of Europe has recognized the 2020 Handbook on AI and International Law as the sole think tank publications from India as an AI initiative, along with the Niti Aayog's 2018 AI strategy. I did not knew this. A friend of mine in the Research Ethics Committee told me that this has happened, and the Secretariat and the Advisory Council is delighted. All of us are delighted. We never expected that it would happen. We just published this because this handbook project, which I started, is an effort of iSail in a way that we wanted to help people and understand how AI could actually affect various fields of international law. And I'm very glad that it has happened, and I'm very grateful that this project was succeeded. It was a youth-led project because most of the contributors are either young law professionals or law students. A mix of them. It's not a majority minority thing, but we are grateful for the love and heartfelt support from all of you. So first of all, thank you for your heartfelt wishes for Council of Europe update. So yeah, that's it. I'll not discuss the Council of Europe update now. I will now discuss the AI Act for which we are here. So I'll tell you what happened, what inspired me to come up with this draft. So in October 2023, the government of India came up with an India AI expert group report. And in October, that triggered an idea within my head that, you know what, why don't we come up with an AI build draft for the sake of God or Devatas, and let's just discuss it among people, because I don't accept the Gen AI hype. Let me be very unprofessional about it. But I accept that artificial intelligence is going to change the world in the best ways possible. Not the open AI way, or not any, I would say, enterprise way, but I think the future will be led by our MSMEs, research labs, and startups. It's not like a bias against any big company or something. I mean, they have all the capacity, all the R&D, everything. But the reality is that AI-led growth will only be happening in a proper manner when at a microeconomic level, our research labs, our AI startups, and MSMEs will be benefited. That should be under a national interest and our democratic and civilizational Bharatiya interest. I know that the government of India, under their leadership in the G20 and the Delhi Declaration, as well as the GPAI, recognized this fact. But the problem was that the AI ecosystem has not been consistent about it, because a lot of AI ethics discourse is dominated by investors or tech policy lobbyists. I'm not going to get into that, whether it is said by somebody in Delhi or Mumbai or something like that. But that triggered a reaction because for a year or so, we have been thinking to draft a bill. Now, in the legal fraternity, the AI discourse became prevalent when I had published an article for India Business Law Journal. Before then also some people and some lawyers have been writing about it. It's not that I'm the first person to do so, but I think what triggered me to draft this bill was the India AI report, which was not a terrible report. It's a good report. It has its own flaws and its own limitations, which is perfectly okay. So the first version came in November 7th. We had submitted a draft to Mr. Rajiv Chandrasekhar, who has never responded back to us ever. I don't know. He must have been busy. We understand. Mr. Bhuvnesh Kumar, also the secretary from METI, has never responded. The second draft was published on March 14th, and that was a reaction because that was an update. We always wanted an update, and that was a reaction because a very dastardly and very terribly written AI advisory was published on March the 1st. And again, that was taken back and a new advisory came in with certain changes. But even then, the METI advisory under the IT rules 2021 doesn't make any legal sense. It can be challenged in a court of law. In my view, again, you can disagree with me with that. But saying that aside, I know certain people asked me if this AI Act is a reaction to the March 1 advisory. No, it was based on the it was not based on the India AI report. It was a reaction to the India AI report, but it was based on the culmination of work that we have done under ISAIL for the past 4 years or 5 years or 6 years. I don't know. So yeah, that is it. So I will discuss a little bit about what does this act contain, and then I will share the screen to explain about every single aspect of the act. And I'll do it in a detailed yet concise manner because I have an hour only, and unfortunately my time does not permit me beyond. So this act focuses on intellectual property management. It focuses on defining an Indian approach to risk management for AI, because we have to favor and support our MSMEs and startups. The approach that we have for bigger enterprises or MNCs, they might afford the compliance cost, but an MSME, which is very unorganized largely, because an MSME is growing, it has its own supply chain issues and distribution issues like a startup has. And it's not just about VC funding, it's actually beyond VC funding. It's also about the fact that you have to make something viable for the public. And at a business to consumer level, AI use cases are very fragile. Gen AI use cases are just useless. Most of them are useless. Very few in the business to consumer segment are good. Either Canva has something great or Adobe has it, but again, it is bigger enterprises. Again, it's a risk and it depends. So we wanted to draft a bill for Indian interests so that our companies who already have a lack of capital, who already have a lack of support, actually are able to do properly. Now, we must commend the fact that the Ministry of Commerce has done an incredible job with the AI mission by, coming up with the required amount and a very simple objective. We don't appreciate the way METI has worked, but we appreciate the digital competition bill, and we also appreciate the efforts by the Ministry of Commerce and Industry. We are very clear about it. So intellectual property management, risk assessment, standardization of AI use cases, which is on aspects of knowledge management. And I will discuss why does it matter to all of you. Okay, so let me do that and let me share my screen. I guess the screen is now visible. So this AI Act.in was drafted, and I'll talk about the acknowledgements in the end because too many acknowledgements are there. It is largely and completely my effort. The very initial chapters, like chapter 1, 2, 3, 4. I mean, 1 is definitions, so not adding that, but 2, 3, 4. Part of it is reliant on the AI Act of the European Union, but only the risk part. Rest of it is not based on European Union's law. It is not based on any other law. Yes, we have examined in the very first draft about the Biden administration, which is the US government's voluntary commitments part. We did that. The second thing we did, which was important, was the Bletchley Declaration under Rishi Sunak's leadership in UK, which is important on frontier AI on safety. Then we analyzed, obviously, the India AI report. It came in October at the same time. It was a very, very panicking month last time, October and November, for AI. Then at the same time, China has 4 laws and regulation of AI, from algorithmic services on fake news, from synthetic content to other things. So the Chinese approach is that data and algorithm is our own ownership. We don't give a damn. We own it completely. So that's a Chinese Confucian Xi Jinping approach. I'm not getting on Xi Jinping or China. So considering all of these approaches, we did not inspire from the Chinese approach because of the simplest reason that in the larger Indo-Pacific and quadrilateral security dialogue perspective, India is kind of allied to the Americans, okay, on information technology. If you look at ORF America's work, or you look at even the work between General Atomics and the government of India, you will actually understand that from defense tech to AI to IT, there's a very good partnership between the Americans and us. So we respect that, and considering that, the draft is molded in that way. If there is anything good from the Chinese approach, we might have it in the third version, which might come in 5 or 6 months. I don't know, based on our time limits and everything, because we also have work and constraints. But it is what it is. So let me discuss the definitions quickly so that we get to the further sections of this draft. So definitions are there, and as you can see, we have defined what is an artificial intelligence system. A basic definition for AI is just like an information system which employs computation, statistical, or machine learning. Because see, what happens is when we say AI, it's a very colloquial term. So anything we see these days, like obviously at a very very basic level, we will say that what automation by robots might or might not be based on machine learning. Again, depends. Or we can say that everything in AI could be based on machine learning. So again, that's the abstract philosophical question. That doesn't mean that we don't understand, but we wanted to have an inclusive definition, which is why we have kept three things separate: computational, statistical, and machine learning. That is a very simple, practical definition we have tried to do. And the definition has been expanded in section 3, because earlier, the first version had everything in this paragraph A. Now we don't have that. Then we have the definition of AI generated content. Now, what is AI generated content? That's a good point to beckon to. AI generated content means anything which is generated by AI. It even could be physical. Again, we have not defined what is physical, because again, it's hard to do. But we have said that it could be physical or digital. Digital is easy: music, text, okay, photos or graphic content, or anything is a combination of all of these three in any ways. It could be something like an entire chatbot which is running on 3 to 5 different APIs of generative AI, which is having this is a joke. This is which is having a LinkedIn account or a social media account and trying to scam you. Even whatever it does by texting or calling or whatever, even that is AI generated content, but hybrid synthetic content, we can say that, right? So synthetic content in multiple forms could exist. TikTok has proved it. YouTube Shorts has proved it. It's already happening around the world. There are influencers which are AI generated, and they are fake also, and they are not sustainable use cases, but they exist. So the draft law, as I have proposed, covers that, which is why we have said it is not limited to text, images, audio, video created. Okay, based on test case or use case, because again, a test case might not be commercially viable for a market, and a use case might be viable for a market, which depends. We have also defined algorithmic bias. We have not included a social part of it, and the reason we have not done it is simply because we did not wish to confuse the issues of human rights with civil law or commercial law, to be very precise, right now. And the problem is, with a global south country like India or an Indo-Pacific nation like us, I think these are constitutional law issues, and we should deal with under the jurisdiction aspect of constitutions. And we should not include it under civil law directly. If you want to talk about human rights, we should talk about Article 21, Article 14, Article 19, and others. And I think our jurisprudence on case laws will be much better to deal with AI-related human rights than a statute. Again, you may disagree with me, but this is a very practical assessment. Recognizing basic ethical principles is great for human rights and fundamental rights, but having a very rigid definition will not help anyone, and it will only confuse government authorities. And again, in the new Bharatiya Nyaya Sanhita and the new criminal codes, you can also have better interpretations. But right now, we have limited to commercial law issues. That's why we have only said that technical limitations and technical biases are AI biases. Now, what could be certain things which might include algorithmic bias? Only 4 things. Programming errors, which is like programming has certain issues. Flawed algorithmic logic, it's like the logic of the algorithm itself is flawed. It's somehow not working in a way, it's working in hindsight, or it's not according to the use case that was intended in an inherent way, which is why we have said inherent technical limitation. Sometimes it's just manifested. Third one is improper data handling. Now, this is something which is contentious. Some people have given me feedback that the improper data handling might be a bit contentious, so we might review it in the next edition. But again, if data handling is not appropriately done, then it might be affecting and causing some biases which are technical in nature, which is why we have kept it. And the third version, we will remove it or change it. But again, we are open to feedback, and that's okay, provided it's not done to mock us, but only to appreciate and be critical, but nice. So yeah. The fourth one is deficiencies in model training and validation. Kind of related to the first three, but an extra thing given for an understandable purpose. Now, obviously, this is there. Uh, this is a very basic provision taken directly from the DPDPA, which is like, because AI and law is under telecom law, therefore an appellate tribunal should be the Telecom Dispute Settlement Appellate Tribunal under the TRAI Act. I don't think we need an AI related court. Our country is just not competent for handling any AI related legal disputes, and I am very, very clear about it. Sadly, our judiciary won't be able to, because there will be too many issues and they are not just about copyright. Therefore, we kept it very clear that it should be under a telecom law tribunal, because it's a telecom law matter also under civil law. So let it be done that way. And if anything new could be added and new competence comes in 20 years, we have better lawyers and judges who actually can handle these issues. And it's not just copyright, right? There are much better and scary AI related legal issues in medicine, pharma, consumer experience, women rights, children rights, right? And we have to deal with that. In that regard, I think a telecom tribunal is much competent, and obviously the matter can go to the Supreme Court, like it happens in the DPDPA, if necessary, under the Civil Procedure Code. Because in the last sections, we'll find the reference to the CPC, because the CPC handles civil law. It doesn't go to a constitutional court directly. Otherwise, you have an SLP, which is a different matter altogether. Again, I can be corrected on the part of SLP and WPC. That's a different thing. Then another important definition is combination of intellectual property protections, which I will discuss later. But it's more like a combination of different intellectual properties that you have, from patents to copyrights to industrial designs to trademarks, even trademarks. And you may say, why? Why trademarks? Well, it does matter. Intentionally or unintentionally, there will be some AI generated content which will be important for the goodwill of a trademark. Therefore, it's a legal issue. Therefore, it matters. Therefore, there will be a combination of IPs which will be in clash. And then for a country like us, our IP offices will have to handle this problem. And therefore, yes, a combination of IP matters. Content provenance, which is basically deep fakes, the whole debate on deep fakes happening due to the Indian Lok Sabha elections. And it's a good debate. I'm glad that as a democratic country, we are doing it. But I thought we should have a definition of content provenance in a more inclusive manner. So we replaced from the earlier parts and we brought the definition here. So it's very simple. Again, we can refine it. We are open to take the feedback, which is to say that any synthetic content or AI content which is generated, it has to establish its three things: origin, authenticity, and history, which includes the source data from where it comes, the models and algorithms which are needed to create this, the individuals or entities involved in the creation, modification, and distribution, and the timestamp and location, if necessary, as to when it was released. And if there is a version 2 or version 3, any modifications done, like it happens in AI generated memes, you would have to show under content provenance at a substantive level. That's the best evidentiary way to do so. Again, if this is not a better method, again, I'm not saying this is the best method. You can recommend us and we'll see what we can do. But for now, it's a good starting point, because something has to be started legally. And I think it's a nascent side for AI to regulate. So anyone can do innovation. So India can do. Therefore, I propose this. And the last one is very important. The last 2 points, point 5 and 6, are very important, because the fifth point is about any external content, citations, or references which are importantly used in the creation of the AI content, including the provenance of external sources. And the last one is about citation loop. So citation loop is like you created a meme based on human efforts on Canva. Okay. And it turns out that somebody created an AI generated meme using Firefly or some other tool. I don't know. They can use it. Free world, they can do it. And then the third person goes back to Canva, uses the second content, and creates a new crazy meme using some other AI tool. Now, how many AI tools are involved? 2. How many times human efforts are involved? 3 times. It's a confusing maze, right? And then again, you got to give this timestamp from the metadata or something. So it's a confusing situation. It creates a citation loop. Then again, the citation loop has to be understood in the context of a controversy or a legal risk which is coming up. That also matters. So in the media sciences, when people write articles on AI and copyright, it's not so easy as it seems to be. That's why we said citation loop matters. The definition of data fiduciary, and data portability has been directly taken from. Data portability is different. But anything regarding data fiduciary, and data principle, we have taken it from the DPDPA. We are very clear about it because the DPDPA is clear about it. So we have allied with the Digital Protection Act, the Data Protection Act. We are very open about it. But one thing which we have added from ourselves, from my own efforts, is basically this: data portability, which is not recognized in the DPDPA, but it is recognized in the Digital Competition Bill. Coincidentally, the Digital Competition Bill came later, and our draft came kind of before or something like that. So, data portability is basically like, can data be interchangeably existent in multiple places at the same time in a way that it is having its own autonomy for a customer or a citizen? If I have my Aadhaar and PAN details or DigiLocker details or whatever I have, which is sensitive information under DPDPA, can I have it in a way that it's like a credit card thing, like not like fintech? What I mean is, you eject or insert. Do you have the ability for automatically ejecting or inserting something in a way that you have your guardrails, so your data is with you and the relevant transaction or the relevant processes are achieved? Do you have that right? Now you can relate it to right to be forgotten and other things, but I'm not getting on that again, because right to be forgotten is a very different thing defined in DPDPA, which is again a different issue altogether. Again, I have done a monologue on DPDPA long time back for the Bharat Pacific. I think it was in September or October. You can look at that, which is, again, it's not a concrete legislation, but it's a good legislation. It's a good way to start, and again, amendments can be done and changes can be done. Digital office, again, taken from the DPDPA. Digital personal data, taken from the DPDPA. But the definition of digital public infrastructure, the very famous thing known as India Stack, this is our definition. And we have given a very inclusive definition to add things. And again, we have said not limited to, because there will be a lot of things regarding AI integration into DPI. And I think it will be a public law matter under constitutional issues. Therefore, if anyone wants to file a writ petition, at least some substantive recognition of DPI must be existing. It's not just about some fintech rules or Aadhaar Act. It should be beyond that, even when AI content is coming up or AI related processing measures are taking place, which is why we recognize the definition of DPI without any prejudice, but with a good intent. The next definition is about knowledge asset. Now, this is something which is very crucial for this whole draft, because we have introduced this for the first time, I believe. I did not think that we had defined it well, but I think in the second draft we did it properly. Now, this is a very critical question, and I think I have had a discussion with an expert on technology, IT, some time back when this draft came in, and he also said that the problem with MSMEs and startups in India is that they will not be able to afford knowledge management practices largely, because it's a very messed up situation. Whatever information or content you have, now what it could be, intellectual property rights, like you have got some patent application approved despite objection. It could be an industrial design application approved, you have a certificate. It could be copyright office registration completed, or you have recognized your copyright by basically publishing and saying that it is yours, basically doing it the right way, which is publication, or trademark registration, which is, you protect your trademark or wordmark, however it is. That is one thing. But even beyond that, what is the documented knowledge behind your work that your AI has been developed? Again, that is complicated. For businesses, different thing. For consumers, different thing. Across sectors is a different situation. Now, MNCs can manage that. Legacy companies can manage that because they have bigger teams of in-house counsels. They have better teams. They have partnerships with law firms. No prejudice about that. They have their resources they can do. But most MSMEs and startups won't be able to have those resources. Their funding costs are huge. Sometimes their customer acquisition cost is huge. So at least for an Indian perspective, let us just recognize a knowledge asset, so that in a civil court or a commercial court or through mediation or ADR, we at least recognize in arbitrations or ODR or ADR what is a knowledge asset. And I think for a democratic perspective, under civil law and commercial law, that was needed to be done, which is why we defined a knowledge asset. Again, this is non-exhaustive. I mean, a lot of things are there, like customer experience related knowledge, which is your analytical insight, organizational processes, what are your SOPs, basically. Okay, knowledge derived from data analysis, as I said. Then tacit knowledge and expertise, which is about like specialized skills, know-hows. Again, know-hows are about, whether it is a transfer of technology aspect or not. which again depends, or it might be an original creation. So all of that is under knowledge assets. At least something has to be defined. So we have done it for that purpose, for documentation, not for stringent regulation, because I'm pretty sure nobody has any idea what to do about this. And it's not about my draft, even in general, I'm talking about knowledge assets. So that's why knowledge assets matters. IDRC is basically my own term. I defined India AI Regulation Council, which is a regulatory body for AI. And I think strongly that we might need a regulation body. It should not be done under the data protection board, simply because you will find out, you means the audience and everyone, that a lot of AI related legal issues are beyond privacy, consent, data quality, and right to be forgotten issues. They start with data, but they will get on issues like explainability contracts, service level agreements, productization, and many other things. Sometimes even consumer law, where data issues might be there, but they just get saturated at such a level that it won't be like a very minor micro level data protection or consent problem anymore. Like, for example, dark patterns is definitely about data protection and consent, because if you're, as an e-commerce company or a delivery company, if you're fooling your customers using dark patterns, it is about privacy and consent. But it does not mean that at a micro level, at a micro managed level, you will handle data protection. You have a data protection act, you have a data protection authority, which is the DPB under METI, and that will handle the work. But that is again about at a very, I would say, parallel and I would say amassed level. But something which is a domain specific issue will emerge, in AI related legal issues are advanced level. So that's why we have not obsessed upon the data part, because we already have a data protection act. I think it's a good act. It is not completely a perfect act, but it can be made better. Now, this is the most important definition of this act draft, and I'll tell you why. So this means inherent purpose, which means that there is an underlying technical objective behind creating any AI technology, whether for R&D. I mean, it starts with R&D all the time, whether it is pharma or agriculture, but it starts for any sector for a technical purpose. There is some objective which always will exist. And if an objective exists, that has to be disclosed in arbitration, or it has to be disclosed in dispute resolution, so that somebody knows who's an aggrieved party as to what was the technical objective. And I think recognizing this is in substantive law is very good for the awareness of the public, as well as businesses and governments across the world. Which is why I think it would be great if some part of it is integrated in some form of draft if the government wishes to come. Again, it would be an honor, and I'm very humble about it. Next part is very obvious. It is already was in the first version. I will discuss this later. Then interoperability considerations, the second most important, very deep, but I will be quick for you. So it is very simple. Interoperability considerations, I've discussed a little bit, about a combinations of intellectual properties before. But beyond intellectual property, I think there's a more about balancing the need for IP protections for context-specific needs. In pharma, it's different. In fashion, it's different. In entertainment, it's different. In gaming, it's different. In financial aspects, it's different. In FMCG companies, it's different. In legal tech, it is very, very different. Very, very confidential, very unique in its own way. Okay. In, I don't know, agriculture for farmers and other institutions related to farming and agriculture, it's a different issue. So intermixing at an ontological level matters. We've also recognized one more aspect to it, which is inspired from the India AI report, which is specifically about spatial aspects of IPs, which is a unique thing the government itself wrote in that report, which is that the spatial nature of intellectual properties needs to be addressed. I don't know what it is, but I kind of understood they are talking about a more wider perspective. Again, they wanted to be philosophical, so that's who they were, and we congratulate them for that. And we have also defined an open source software, which is a very basic definition. We've also defined something called a national registry of AI use cases, which is like, you have use cases, you need to get it registered. It is partly inspired from a very interesting paper by Mr. Sanjeev Sanyal, who and Mr. Chirag Dudani and Mr. Pranav, who actually wrote about a registry of AI use cases. But again, we have been proposing about that even in the November draft. In this draft, we have been more specific about it. Again, we are thankful partly that, they kind of urged us, but I think their paper came in a different time and we had already started drafting. Still, we are very grateful to them. This is a very basic definition, straight away taken from DPDPA. What is a person? Like a Hindu undivided family, company, firm, blah, blah, blah. This is a very common thing. These are common definitions from the first draft itself. Significant data fiduciary is also something we also recognize because it's a civil law issue, therefore it will be recognized. Then, yes, as I said, spatial aspects of AI systems. Now, we have actually taken a unique definition of it based on the India AI report, but the five conditions that we have put are unique. They are not proposed by the India AI report. They have just based on what they might have been trying to do based on our analysis. So, dynamic adaptation and generating novel outputs, and mixing different kinds of generative AI content together. So, spatial aspects, whether it is interdimensional in a very practical world that we live in. So this is defined in that particular way. Then other definitions like state as per Article 12 of the Constitution, very basic definition from the DPDPA. Then strategic sector, again that is taken from the RBI regulations, which is the Foreign Exchange Management Overseas Investment Directions of 2022, which defines what is a strategic sector. So it is directly that definition taken. We have not defined it here because it's very long and we did not wish to do that here. Then there are basic definitions like training data, testing data, use case. Last one is all based on the Digital India Act proposal, partly, which is whole of government approach, which is like a corporate affairs ministry, for example, partnering with METI, which is partnering with the Ministry of External Affairs, which is then partnering with the Ministry of Home Affairs. So all ministries are coming together and partnering. And it's a cooperative form of government governance in certain ways, which is a whole of government approach. The best example of that, if you find right now on the internet, is NSWS. Search that on gov.in, you'll love it. It's a great thing for registration of certain government IDs for businesses, from GST to PAN to whatever. It's a great thing. You can try that. So yeah, we are done with definitions and it's already been kind of 30 minutes. So I'll be quick with other chapters. Okay, this is the most important part. And then I will discuss IP. So this is categorization and prohibition. Now, we have not created what should be prohibited right now, but we have tried to also create a jurisprudence out of it that, what, if we have to have some factors, what it could be. And again, we have decided to clarify section 3, 4, and 5 in the third version whenever it is out. We don't know when it will be. Based on our availability and everything, we'll actually work on section this chapter 2 and we will actually make it more clarified. But I will explain what these are. For example, the first one is a conceptual method of classification, and I'll tell you what it is. So in the conceptual method, we have 4 ways to classify AI. The first one is issue to issue concept, which is like a bit of a conceptual understanding. And I'll tell you why conceptual methods are important. First, even in the European Union AI Act, Annex 1, the abstract nature of AI has been recognized in one of the clauses. We have just expanded in our own way. And what we have done is, in the first one, which is issue to issue concept classification, the idea we have taken is that there will be specific issues based on which the technical objective. You remember the definition of inherent purpose. Now you can relate why inherent purpose matters. You can define and redefine inherent purpose, interpret based on this, basically. So what is the specific issue to issue relationship that an AI is important? The second way to do it is ethics based classification, where you recognize the ethical relationship of AI technologies in specific sectors. For example, if you are using a sensitive AI application in some sector and you're worried about it, whether it would be affecting you or not, then I think you should know if an ethical implication matters. So from a substantive law point of view, ethics based is very specific. We have not given a very abstract definition. We have just said that it's about the ethics based relationship of an AI technology. But I agree, we agree with the feedback that I think it needs to be simplified more with illustrations, like it happens in Bare Acts. We should do that, and we will take that in the third version for sure. But I'm just clarifying for the sake of the audience. But I think because it has been a month since the second version came out, and I wanted to do a monologue on this. The third version is the third way to classify in this first way of classification is phenomena based, which is like you have a set of economic trends or you have a set of policy trends, which is more about economic rights and legal rights, since it is a civil law legislation. And if there are rights based issues, human rights, commercial rights, legal rights, rights related to, I don't know, environment and others, if there are some tangible rights based issues, phenomena kind of matters when it comes to the dissemination of AI. Again, we are trying to revisit this definition, this part, and we will do that in the third version. But the fourth one is extremely important, which is anthropomorphism, which is like, imagine that you have been using ink based pens, that dipping a feather into an ink bottle so that you could write, and you shift from that kind of writing method to a ball pen, or an analog watch to a digital watch. Now, that is actually an example of anthropomorphization, which is human attribution, which is to say that any technology which is developed is attributed to human things and becomes a part of human lives and things in such a way that beyond its ordinary purpose, it actually becomes an integrated part of human life. And I think that is a very important philosophical aspect which I wanted to address. Again, we can make it more specific, and we should make it. This is a very unique category that we have given, but I think it matters in a lot of commercial issues as well as rights based issues, which is why attribution, and we have been very clear about it. How AI systems do it, there are very specific ways we have defined. AI systems can simulate, mimic, imitate, replicate, or emulate human attributes, which includes human tendencies of three types, not more than that, only three types: autonomy, perception, and behavioral tendencies. Again, in the third version, I think we might have a schedule or something to redefine this properly, and we'll come up with that. Then the second method is rather easy to say, which is a technical method to do. Technical method specifically means that there are three to four kinds of AI applications. First is definitely like a chat GPT kind of a tool, or Anthropic's Claude, which is like a larger application, Gen AI application, LLM based application, which has too many use cases. You can draft a visa itinerary. If you care about your privacy, you won't, but you can come to know about some cooking recipe from Anthropic's Claude or Gemini. Okay, you can do AI art generation also through chat GPT 4, okay, which is turbo. You can also do it, you can also get some script created. You can also do translation. With translation, you can also have some other micro use case, but again, is it a sustainable use case? We don't know that. So that's why we have actually, it's kind of like a general purpose AI systems, but for Indian perspectives, we have started general intelligence applications. But again, there are two perspectives. First is like, maybe within 6 months or 12 months, or maybe a longer time, we see that it is industrially viable, which is again a contentious question. No government has been able to define it properly because it's a very risky issue. Even for the Chinese and the Europeans, it has been difficult. So general intelligence of two types: either you have a stable AI use case, or you have a chatbot which can't even survive beyond 6 to 12 months, therefore an unstable use case, which is based on sector specific and sector neutral industrial standards. And we have those standards, ISO standards and many other standards. So whatever be the sector application, we have kept that part open. We can't impose on others, therefore it is what it is, but it has to be recognized legally, which is why we have done that. Third way to do in the technical method, for everyone's convenience, is this. Let me just show it. Yeah. So this matters a lot because the third way is actually very interesting. The third way is about AI applications with one or more use cases. For example, Quillbot can do plague check using AI and its own libraries like Turnitin and all, but at the same time can also do AI writing for you. So Quillbot or Grammarly have 2 to 3 stable AI use cases. They're making money out of it. They're getting revenues. They have very specific AI use cases. They are not ChatGPT. They are not Gemini. They are not Perplexity. Even Perplexity is a very unique thing with its own specific use cases, as much better as others, which is again my understanding. But I'm giving you an example. You can disagree with me on that. That is fine. But I'm just telling you how it works. Then there's also a way to classify AI, which is a commercial method, which is an industry method I think we should follow, which is a common method accepted everywhere. For first is obviously AI as a product. If you define a product like, that device by Rabbit or an AI watch, again, sustainable or not, sellable or not, that's a different question, but it is an AI product. You can launch a product if it fails, right? Second is AI as a service, like a subscription from a Copilot or GitHub or whatever. Okay. Then AI as a component. You integrate certain APIs which are sellable. You integrate certain applications using APIs that are sellable. Again, that is a different question, but we have been very specific, which are directly integrated into existing products, services, and system infrastructure. And the fourth one here is in classified and commercially is AI as a system, which is about infrastructure layer and basically technical aspects, a part of AI as a service, which is like offering certain kinds of which AWS does, Azure does, and even Google Cloud can do, Llama services, all those things. And the last one is AI enabled infrastructure as a service, which is also kind of based on the Donald Trump administration's or executive order, which is the US government's executive order long time back on infrastructure as a service and AI on national security issues. This was kind of based on that, but is also kind of related to DPI, because then you will integrate AI to process Aadhaar data. If you would, I don't know if it will happen, but it can happen, right? Logically, you can. Legally, if it is viable or ethically it is right, I'm not questioning that right now because that's not the topic of the discussion right now. But you can do that, right? So obviously, AI enabled IaaS or infrastructure based SaaS service product. So these are the commercial ways to do. Now the part which we took from the EU AI Act, and again, this is completely new because the European approach is unique. We have taken a different way. Now we have defined four kinds of classifications. One is narrow risk, second is medium risk, third is high risk, fourth is unintended risk. Unintended is directly taken from the AI Act of Europe, which is like you have to ban certain applications in public and private sector which are risky. And again, the definition is that they may not be deliberately designed or developed but emerge from the complex interactions of the components and system infrastructure, which is based on the European definition. But the narrow, medium, and high are the interesting ones. Why? Because if I may make you remember, we had discussed about inherent purpose, the technical objective, right? So substantively, if you have to do risk management and the matter goes to a court or matters goes for arbitration, then how would you define a narrow risk AI? Again, industrially, it's a complicated question. But we have said that it might, and again, the kind of risk that we have assumed are outcome based and impact based risks, not some abstract risk which is just defined for the sake of it, but outcome based, what has happened, what might happen, and what is the after effect of it, which is the impact. If X has happened, what is the Y which is happening after it? So it is based on the X and Y, outcome, impact. That's what we have done. It's very practical, very specific, nothing else, which is what we defined, so that it doesn't create a confusion and in the name of risk over regulation happens, which we don't intend that it happens. So yeah, narrow risk means obviously low level of risk, society or environment, kind of a little taken from the AI Act, subject to their scale, how much scale they have, technical objective, inherent purpose, technical features, what exactly that are the technical features, and the limitations. I'm referring to the bias as well a little bit if there is, because AI systems will be biased. There is no AI system which does not have AI bias, right? It will have, but again, a low level one. Now, how do you designate that? Again, that can be argued later, and a schedule could be prepared by me later. But still, it's a good way to start a discussion, at least, right? You might disagree with me, but I think at least because of this definition, at least you will discuss. I think that completes my objective. That's what I wanted in a democratic fashion. Second part is medium risk. In medium risk, you have a moderate part, moderate risk. But what we have done is we have removed the inherent purpose aspect, which means that even if you might have a good inherent purpose, you may be classified as a medium risk AI system, and inherent purpose does not matter here, irrespective of it. And therefore, we have limited it to technical features and technical limitations, because at some point, your objective might not be a way to defend yourself. Because we have to see how companies can defend themselves as well, right? It's not just about big companies, it's about everyone, even an open source community. So that's there. A third one is high risk system, which is very important. And at that, we have stated that there is, regardless of any aspect such as scale, inherent purpose, technical features, and limitations, some systems are high risk. Even if they are not banned, they are high risk based. And I think I agree with the feedback I received in certain groups and discussions that something has to be further defined in section 3, and we will do that in a schedule or something later. But we will do that, promising. I'm promising we will do that. We are not lying about it. We don't have any issue doing it, so we will do it later as much as our knowledge is. um, the very paragraphs 2 in this is very obvious. I'm not going to discuss that because that's a different issue altogether. But yeah, prohibition is very common provision, like in the EU AI Act section 4. Sorry, so it's the same. I'm not going to discuss this. I'll jump right away to something more, because this is again a very basic thing, that there are high risk AI systems, and for high risk systems you have to build sector specific standards no matter what. And every AI model is not high risk based. High risk is like maybe an open AI, because it can be used for hacking. You can use generative AI for hacking. You can actually come to know, unless obviously that hallucination is prevented by the developers. That's a different issue. But you can use open AI tools for hacking indirectly by saying, you know what, my grandma told me this. Those reels coming up, and they're true, by the way, that you can actually come up with content which actually can help you hack. And you can do it in older versions of Windows XP or 7 or something like that, or older versions of Mac, if you can. I don't know, but you can use generative AI, and that's a very big error. There are some Gen AI tools in the dark web which are trying to come up for hacking. So it's happening, right? It's happening in front of our eyes, right? So that's the basic thing why high risk systems matter. These are high risk systems, not your banking chatbot, which again could be high risk, but depends what's the use case. Which reminds me of a joke, just quickly before we go to the next part. Somebody made a chatbot for a company, and the chatbot was not helping the customer. The customer was like, why are you not answering my question? And the chatbot hallucinates and says that the owner and the customer experience team has not been helpful. And the chatbot is ranting like a baby, like a human being. So generative AI can also do these things. That became a media news. Okay, jokes over. This is a bit important thing, so I'll discuss this, which is certifying AI systems, which is only for high risk systems right now. We have only made it for high risk systems, but at a uh, at a voluntary level, MSMEs and startups can participate if they want to get it certified. Again, that is not a label, but again, based on the nature of their use case, they can try to do it. That's why certification matters. And then you have ethics code, which is a basic ethics code, which is like AI systems should respect human dignity. It should be fair and non-discriminatory, and social justice based on the values of Dr. B.R. Ambedkar and directive principles of state policy of the Constitution. You should do that. We are Indians. Yeah. AI system should be transparent. Absolutely. Therefore, the ethics code is only for narrow and medium risk systems. Although they will also apply to the other risk-based AI systems. But they're like an ethics code which can help you in civil law to say, you know what, these were the ethics code and the companies are not following it under consumer law. So you can actually have those discussions, right? And that's why it was drafted. There is some part for open source, which is very basic, that just because you have open source in AI, it does not exempt AI systems from complying with the principles in this ethics code. Very basic. This one is very important. I'll discuss that a little detail, and then I'll go to some other chapters. Section 8, which is model standards. Now, what is model standards? So first of all, the model standards are for high risk AI systems. I have not done it for MSMEs, because I don't think that a student from IIT who is trying to develop their own bootstrapped AI model from Kerala, or I don't know, somewhere in Guntur or Hyderabad or Lucknow or Delhi, that person will not come under a high risk system. It would be some startup or MNC or somebody who would have too much data set, too much resource, too many resources, and a very critical sector, right? Like you are in energy or agriculture, and it is affecting people, then it is high risk, right? So high risk is in that way. Again, the government has the right to signify that. We have those things in our draft act, that which again depends. But what are these knowledge management standards? So very simple thing. First is uh, you should ensure the quality, reliability, and security of your data used. So it starts with data protection to improve your AI systems. Then you should have some model governance frameworks within your companies And again, big companies can afford that. In the digital competition bill, we call it the SSDEs, significant beneficiaries in that sense. So yeah, and you have to have some AI committees or bodies which have individuals departments. Third is transparent decision making, because I'll tell you this, in aspects of patents and design there will be a lot of legal issues coming, and we should defend our MSMEs and startups who will try to get their AI applications patented. Because if you can patent a process, you can actually get an AI patented. That's what is the precedent in the UK High Court, and we have discussed it before. Even in the American patent offices recognize this thing. So Indians should recognize this. It's a good way to do within the existing IP framework. There's no new aspect which has come up. It's a very commonsensical way as a guideline. So that is definitely there. Then these are based on prescribed model standards within a reasonable time frame which the regulator has to decide. So obviously entities which are doing that have to do that, and therefore it is necessary to be done. Okay. Section 9, it's more about a bureaucracy of a regulation body. So it's a very same kind of a same thing like the DPB, the Data Protection Board. So nothing unique to discuss in that. I'll skip this one because you can read it. It's basically like who will be the chairperson, where will be the headquarters. I wish it happens in Bhopal or some other place, not Delhi, but you know what, who knows. But yeah, if there's an AI regulation body, I don't know. But this is more important also, which is section 10. So there are some kinds of agreements which are important for everyone to know, which will come in being, and they are based on some important commercial law agreements which have been there for time, like a software license agreement, which you sign in the very beginning when you install a software. Then we have just made some guidance principles. Like under commercial law, these are certain things which a contract should have. That is kind of like how it happens in the Arbitration and Conciliation Act, that there should be certain things mentioned in a model agreement or a contract, right? So obviously a contract is a legal document. Therefore, for an agreement, what it should have, that is what it should have. That is what we have defined. Second kind of agreement is a service level agreement, which is what is the level of service offered, right? What is the mechanism to monitor and measure service performance? Another one which is important is end user agreement, which is exactly what you sign as a customer. Software license is a different thing altogether. It may be commercial, it may be not. The last one is the most important, which is AI explainability agreement, where you make explainability of your AI systems clear, because that could be a matter for telecom arbitration or technology arbitration in 10 to 20 years or 5 years. We don't know. Even if an MSME won't, or startup wouldn't go for a mediation or arbitration, it is a legal issue, and I believe that if a privacy policy and under the DPDPA you have notice provisions, you need to have AI explainability agreements if you are building an AI. Maybe a minor agreement of 5 to 6 sections, but you need to have some saving clauses, some boilerplate clauses. And I would be happy to help on that if somebody needs help on an explainability agreement. But I think an explainability agreement is a good way to start for a better market ecosystem on AI. Okay. This is a basic thing what a regulator should do. I don't want to discuss that. This is more about post deployment, which is like, okay, if you deploy, what could be the risk mitigation measures, which is again only for the high risk AI systems, not for the small ones right now. Again, this can be amended and this can be reviewed, but we have kind of kept it simpler so that maybe if part of it is considered somewhere or built into a market principle, at least it helps our startups and MSMEs to thrive. That does not mean they should not be subject to regulation. They will anyways be subject to fintech regulations or some data protection laws. So they're already under regulation. But for AI as a tech and AI as an industry, I have just cut some slack for them. Maybe, but yeah, I have done that. This is again third-party vulnerability reporting and incident reporting, basic provisions. These guidance principles are not a part of the bill, but like kind of a schedule or kind of a circular, as we say, that we can actually, So yeah, and responsible information sharing is basically based on appropriate safeguards, and this is kind of a data protection issue. Like data fiduciaries and third parties must describe a set of general practices which are applicable to development community. That's why section 14. This one is the third most important part, which is intellectual property, and I'll tell you why. You remember I had talked about multiple IP protections. So in multiple IP protections, there are aspects of development of AI, by creating enforceable and secure rights. and that has to be done by enhancing the interoperability of AI systems by basically coming up with better contractual agreements. And again, it should be recognized in substantive law, which is why we have come up with it. That's the simplest logic. Then you should promote for competition in the market by preventing unauthorized appropriation and exploitation, and I think that should be recognized in the substantive law, which is why it is existing. Privacy and security also is there in the connection of it, so it's like a back-end provision to begin with, which is why intellectual property standards matter a lot. But again, another important part which is necessary to be seen is what will these consultative mechanisms address? The interoperability considerations, compatibility of such protections with IP laws, and the use of open source software. And I think that kind of matters, which is why we have put it. This is again section 17 based on the very definition of content provenance, AI generated content and all. So this is there. And the guidelines if should be there for deepfakes or any. I think there are 4 ways to do. First, what kind of information is embedded in watermarking? If you're watermarking a content text-based, I mean, text-based is impossible. But at least you can mention it somewhere. It is AI-generated blog or something. Or for videos, you can do for others. But if you do some watermarking, you need to tell at least what information is there. And that should be standardized under the guideline. Okay? Then, licensing of a watermarking technique is very, very important when more deepfakes are coming in future. That can be done smartly by encouraging a set of enterprises which can do that, and then they need to do it fairly without any bias. Maybe they are an intermediary under the IT rules, in my view, like a social media company, but I think they should do. And maybe the government then should intervene in a very reasonable, soft touch manner. If the government wishes to do, again, it's a contentious issue because then independence and constitutional rights. So that's a different question altogether. Then robustness of watermarking techniques, whether your watermarking technique is robust or not. And accessibility of information. Where's the metadata? Where is the relevant information? I think basic guidelines can be created, and I think those who are in this community actually can contribute much better, but I think some substantive provisions were needed. So this is what it is. Then we have employment and insurance. Employment is very basic, which is like the whole thing about AI and losing jobs. I don't think the future of work is going to be affected by AI that drastically. What will largely happen is that there will be certain AI use cases which work and there will be certain which don't. So your job might or might not be gone depending on if you are valuable or not. It does not mean, okay, fine, I will be replaced by AI. No, it won't happen. Content creation, maybe, yeah, partially, but not for everyone. So yeah, not a common thing, not an industrial revolution happening. Therefore, very specific standards on employment and skill security. Insurance part is interesting for all of you. The fourth most important part of this act, draft act, obviously, which is what is the insurance policy. Now, for privacy and consent issues, privacy and issues, insurance policies for data centers and data protection centers, they exist. But for AI, I don't think they do. I mean, you can interpret, but that is only for technical aspects to argue, but they don't exist. So we have a few ways to define how insurance coverage for AI related issues can be done. First is technical failure. Second is data breach. Third is technical and not social. Again, you know why. Can't be done. No, nothing tangible, unclear. Therefore, no social, but only technical forms of AI bias subject to the inherent purpose of the AI technology. You have to let us know what is the technical objective, how much information you have, and then you can have better insurance claims in a transparent manner. Maybe at least the relevant insurance regulator should know that. I think that's a much better way, because insurance regulatory authority needs to come up with a regulation or guideline which is important. A circular may be helpful. Even that is enough. You don't need to do too much on this. Then data protection and privacy risk, blanket approach that yes, if it is a consent problem or privacy problem, we have taken from there. And the last one is accidents, which is basic in an insurance law provision. We have just added it. So that was needed. So obviously, the IRDAI will work on 3 issues, which is assessment methods, premium calculation methods, and claims processing standards. That's how it happens. So this was for section 19. And the last one, I don't want to discuss it with anyone because these are very basic provisions. Like if you want to have an appeal, the appellate body will have jurisdiction under the CPC, which is a civil law jurisdiction, right? It won't be under constitutional law or public law or administrative law. It will be under civil procedure code, right? So it's under, because it is a commercial law matter, right? It's between two companies and individuals. If you file a case against a company, again, unless it is about constitutional rights which is involving the government or the state, it's a civil law matter, it's a private law matter, whether it is a lease deed or a rent agreement or a contract on IPs. You have to go to a civil court or a relevant body for that, right? Happens in family courts as well. The same happens here. And these are miscellaneous provisions we have just made out of our head, that if you have to amend certain provisions, what provisions could be amended and what power does the regulator have to make the rules. So this is like a sample of it, what could be amended, like the Copyright Act or the Patents Act. And this is basically a saving clause which I don't need to discuss. So yeah, that is it. I am done with this. I'm happy to take any questions if there are any. And let us see if there are any questions. I'm waiting for them. I'll give everyone a minute. Please take a minute to decide and send in any questions. This was a 1 hour summarization. You can binge watch it later for sure. But yeah, this is aiact.in. But to conclude, before I take any comments from people, I'll go ahead with the acknowledgements not to waste time. I am grateful for some of the inputs by the R&D committee of AIGA, at least for the National AI Strategy 2024, which we had proposed. And their discussions kind of helped us in making the version 1 of the AI Act better. In the second one, we did not take much inputs. We couldn't. But the feedback was there from external contributors and general public. So that was more than enough for the second version. Third version, we are open to take any feedback. Let's see what it is. We will accept or reject any feedback based on its necessity and value, and we'll see what could be more appropriate. And again, everything is up to discussion. But I'm glad that the world and our tech community and the legal community has kind of appreciated the AI Act draft. So I'm very grateful to all of you. Thank you so much for attending this live stream. So yeah, if there are any questions, I am still waiting them. You can ask me questions on LinkedIn Live or YouTube Live or Twitter Live or X Live, as we say. We're not live on Insta yet, but yeah, I'm waiting. Okay, so as it seems, I think it's been nearly a minute and no comments have come so far, which is perfectly fine. I think if you find me on X as Indus Think, or on LinkedIn as Abhivardhan, or on Instagram as Abhi Global, or on Bharat Pacific on YouTube, you can actually ask me through. You can go to our website, which is aiact.in, literally, and you can connect with us and send us your comments at global@indicpacific.com. And please send us your comments. We'll be happy to take them up. Thank you so much for attending this live session. It means a lot to me, professionally speaking. And yeah, that's it for Indus Think for this episode. Thank you so much. Thanks for watching.